All right. I had a unexpected problem with my previous live stream, so I've had to start a new stream, and hopefully people will follow me over here. I also don't know exactly when the audio cut out on my last um, live stream because apparently the audio cut out at some point. So I'm going to backtrack just slightly and I might repeat a little bit of what I said before, and then I'll continue on from there. I hope people have been able to follow me over to this page. Give me 1 second as I um, good. All right. Well, thank you for those of you who are still with me. Thanks for your indulgence. I know this is running long, and I'm sorry for the technical issues. But let me just continue. I had been speaking on the case about the Railroad Retirement Tax Act, and just to wrap that up quickly. So Justice Breyer, in dissent, had basically concluded that the better interpretation of the term money remuneration was broad enough to encompass stock options. And he specifically, he also touched on the issue of Chevron deference, the concept I talked about in the last case, saying that to the extent it was ambiguous, the term money remuneration, the agency interpretation is reasonable, and so the court should defer to that. So that brings me on to the next case. We've got two cases left. I'll try and run through these pretty quickly, but these are the two of the bigger cases. Do I have... I have another note in the live stream that I've lost audio again. Is there audio now? Okay, good. All right, so let me continue with the last couple cases. I'll try and hopefully I can clean this up a little before I post it as a audio podcast. So I have two more. No problem. Okay, two more cases to cover. One is a case called Lucia v. SEC. Now, this is a case that's about the constitutionality of the appointment of the SEC, that's the Security and Exchange Commission's administrative law judges, referred to as ALJs for short. Now, this was a 7-2 decision. Now, Justice Kagan wrote the majority opinion, and she was joined by the 5 more conservative members of the court. Now, Justice Breyer also was with the majority, but he concurred in the judgment in part. So he wrote a separate opinion. He disagrees with the reasoning of the majority, but comes to the same result. Justice Thomas also had his own short concurrence, joined by Justice Gorsuch, and Justice Sotomayor was in dissent, joined by Justice Ginsburg. So let me give a little background on this particular case. So the Constitution establishes particular methods of appointing officers of the United States. There's different methods depending on whether they're what's known as principal officers or inferior officers. But here's the language. It says, the president shall nominate and by and with the advice and consent of the Senate shall appoint various things. And it says all other officers of the United States whose appointments are not herein otherwise provided for and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So basically, it establishes two separate categories of officers, what's known as principal officers and inferior officers. It says that principal officers have to be appointed by the president, but it says that inferior officers, Congress can by law have those inferior officers appointed by the president or optionally by heads of departments. Now, there's a different category of federal government personnel who are just referred to as employees. Now, employees are a separate category from these officers of the United States, and employees are generally just hired through normal civil service hiring processes. They're not appointed through these appointment processes. Now, there have been some cases that challenge this line between what's a principal officer and an inferior officer, but here the question is the line between officers and mere employees. And the challenge here is to the Securities and Exchange Commission, the SEC's administrative law judges. Now, there are ALJs in a number of agencies. They're not judicial officers; they're agency officials, but they have a judge-like position. They oversee trial-like adjudications. So SEC ALJs, they work for the Securities and Exchange Commission, and they conduct adjudications that are very trial-like within the SEC. The issue here is that the ALJs are not selected by the commission itself. Now, the SEC, the commissioners of the SEC, the commission, is deemed the head of the department for the Securities and Exchange Commission. It's the head of the department. So under this constitutional provision, if the administrative law judges were inferior officers, they could be appointed by the commission itself. But they're not appointed that way. Instead, they're selected by certain SEC staff, not the commission directly. At least they were. This has changed since then, but they were at the time that's relevant to this case. They're selected by SEC staff. Now, in this particular case, the individual involved, Lucia, was an investment professional who had been charged by the SEC with fraud due to presentations to potential clients. And he was tried before the SEC ALJ, and he was found guilty, and there's pretty severe consequences. He was stripped of his license in the securities industry. He was barred from the industry, and he had a substantial monetary fine. Now, he has argued that the charges against him were flawed and unfair, but the challenge here is a constitutional challenge. He says this ALJ, because it's an officer of the United States, that the ALJ was an officer of the United States, but was not appointed according to the constitutional requirements, that this was an unconstitutional appointment, and so his adjudication was under an unconstitutionally appointed officer of the United States. Now, Justice Kagan writes the majority opinion in this case and finds that, in fact, this ALJ was not constitutionally appointed, agrees with the challenge, and says that this was unconstitutional appointment. And her opinion is pretty short and to the point. She says the ALJ has extensive powers that are comparable to a district judge conducting a bench trial. And she points to the key precedent here is a case called Freitag v. Commissioner, a 1991 Supreme Court case. Now, that case dealt with what are known as special trial judges, or STJs, of the United States Tax Court. And those judges, the special trial judges, they presided over hearings, but they could not issue final decisions in major cases. However, the court in that case found that these STJs exercised significant authority that was enough to make them officers. Specifically, they took testimony, conducted trials, ruled on the admissibility of evidence, and they have the power to enforce compliance with discovery orders. And so the court found that in the course of carrying out these important functions, the STJs exercised significant discretion. So these are some criteria the court found was important that made them officers. And Kagan basically says ALJs exercise basically the same authority as the STJs. They take testimony, they conduct trials, they rule on the admissibility of evidence, all these same things. They have significant discretion. She points to one difference, but says it's not particularly significant. The STJs, the ones in the previous opinion, their opinions were always reviewed by a tax court judge after they were made. Now, the ALJ opinions in the SEC, they become final only when they're subject to review by the SEC, by the commission, and they become final when the commission either reviews them or declines to review them. Then they can become final. But Justice Kagan said that's not a crucial difference. They both have very similar authorities, and so because the Freitag case decided these STJs were inferior officers, it follows that these ALJs are also inferior officers, and therefore were not constitutionally appointed. Now, she moves on to discuss the remedial issue, and by that I mean, okay, so they're unconstitutionally appointed. What do you do about it now? This adjudication happened under an unconstitutionally appointed judge. What do you do? Well, importantly, since that time, the SEC went back and they did what they referred to as ratifying the previous appointments, and they basically were kind of saying that they were reappointing these ALJs. The same ALJs that had been appointed by SEC staff are now appointed by the commission itself. And so they say this should cure all problems. Now our ALJs are constitutionally appointed. Justice Kagan says that the appropriate remedy is a new hearing before a constitutionally appointed official, but she further says it should not be the same ALJ that heard the case originally. She says, because, quote, he cannot be expected to consider the matter as though he had not adjudicated it before. So the end result is that Lucia, the petitioner in this case, the majority says Lucia should get a brand new adjudication in front of a brand new ALJ. Kagan does say in footnotes that this isn't an absolute rule, that here it's appropriate because there's other ALJs available who could hear the case. It might not be appropriate to require a different adjudicator if it was a situation where there just wasn't someone else available that could serve that role. And the court doesn't touch the issue of the legality of the SEC's ratification of prior unconstitutional appointments. It leaves that as an open issue that could potentially be challenged or decided later. So moving on to Justice Thomas writes a concurrence here. Now, Justice Thomas agrees that the authority from the Freitag case, the type of authority that was determined to make someone an officer in the Freitag case, is sufficient to make someone an officer. But Thomas says that the court should do more to specify, because this case doesn't really advance the case law as far as making it more clear for federal officials who are different in significant ways from the ALJs or from the Freitag judges. It gives very little guidance on what the standards are. And Thomas says the court should do more to define what are the necessary conditions to make someone an officer. And he gives his own explanation there. He kind of goes into a historical inquiry, and his opinion is heavily reliant on an amicus brief and some scholarship of a law professor named Jennifer Mascott. And he adopts a standard where he says basically all federal civil officials who perform an ongoing statutory duty, no matter how important or significant the duty, those people are all officers under his definition. He says this was the ordinary meaning of the term officer was just anyone who performed a continuous public duty, and officer of the United States just meant a federal officer of the federal government. And he says under this standard, the ALJs easily qualify under this standard. But this is a potentially radical change that would turn a huge number of federal employees who are currently just deemed employees into officers under this definition. It's an interesting concurrence that takes this pretty radical view, but there's no evidence that larger portion of the court has any interest in adopting a standard like that. However, again, the majority leaves it wide open what the actual standard is for things that are significantly different from the ALJs. That brings me to Justice Breyer's concurrence. Now, Justice Breyer argues, and I'll come back to this in a minute, but he says this constitutional issue, the issue of the constitutionality of the appointment, he believes this can't be correctly decided without also deciding an issue about the constitutionality of restrictions on removal of these ALJs. And the court had explicitly decided not to take up this removal issue that the government had actually asked the court to decide the removal issue also. Now, I'll come back to that in a minute to try and explain what Justice Breyer is getting at here. But Justice Breyer decides the case on a very different grounds. He says there's a statutory ground for this decision. And he looks to the Administrative Procedure Act. Now, the Administrative Procedure Act, which is referred to as the APA for short, is a major federal statute that sets the general ground rules for federal administrative agencies. Now, and here's language from the APA. It says, quote, each agency shall appoint as many administrative law judges as are necessary for hearings, and then hearings governed by the APA, basically. And he says, in this case, the agency means the commission. And so it said the commission shall appoint. The commission didn't appoint these justices, these ALJs. And he says there's no statutory authority for them delegating this appointment to someone else in the commission. And so it just fails to meet the requirement of the APA in the first place, and this should just be decided on this pure statutory grounds. And he says this is the preferred method of deciding this because it avoids difficult constitutional questions of officers versus employees, and it's enough to just decide it on the statutory grounds. Now, here's where he discusses in more depth why he thinks the removal issue that the court didn't decide here is relevant. And this comes down to a Supreme Court decision from a few years back called Free Enterprise Fund v. Public Company Accounting Oversight Board. And that was a case that was challenging this the Public Company Accounting Oversight Board, which is a federal agency. And the court held in that case that because of the Constitution's grant of the executive power to the President of the United States, that the Constitution was violated if there was too much insulation of officers, of executive officers, from removal by the President of the United States. In that case, it involved officers who had what was referred to as double for cause removal, where those officers could only be removed for cause by a superior officer, who in turn could only be removed for cause by the President. And the court said that this type of insulation from political control by the President was too much and violated the Constitution. Now, that decision was limited to officers. It didn't decide the case for employees. It decided that it left open whether there was any similar restrictions applied to employees. But it said for officers, at least, this type of insulation was unconstitutional. Now, Breyer points out here that these ALJs, the ALJs at issue in this case, are similarly insulated from removal. But he points out that the APA, the Administrative Procedure Act, was intended to protect the ALJ's independence. There's a reason they have this protection. It's to protect their independence, because you want adjudicators, people acting as judges, to be independent from politics. But what he argues here, and this is the interesting argument, he says if these ALJs fit within the scope of the Free Enterprise Fund ruling, that ruling about the unconstitutional protections against removal, if they fit within that framework, so that they would be similarly unconstitutional. If they were officers, they would be similarly, it would be unconstitutional for them to have that removal protection. Then this would destroy ALJ independence. And he says that this is contrary to Congress's intent. Congress clearly wanted these ALJs to be independent. And therefore, he would infer from this that Congress had no intention to make ALJs officers of the United States. And so this is the interesting piece here. It's kind of reasoning backwards from that conclusion. But he argues that the Constitution should be interpreted to give Congress a significant amount of leeway to determine whether a particular individual is an officer versus an employee. And given that he thinks that that is, at least to some significant degree, in Congress's hands, the fact that Congress wanted them to be independent, and the fact that if they were officers, they would lose their independence, would be grounds for thinking that Congress had actually made them just employees. So it's an interesting, it's a very different style of reasoning from the majority. Now he goes on to discuss a very separate issue in his opinion also, and this is the remedial question, where the majority said that when this gets sent back, a different ALJ should hear the case. Breyer disagrees with that. He says that there's really no reason the original ALJ shouldn't be able to rehear the case now that they're constitutionally appointed. He compares this to a district judge after an opinion is reversed on appeal, where the case normally goes back to the same judge. And he says that there's no structural protections are violated now that the problem is cured. And for that narrow portion, the remedial question, he's actually joined by the dissenters, Justices Ginsburg and Sotomayor, who say, well, if this is going to be remanded, they agree that it can go back to the same ALJ. Now, that brings me to the dissent. So this is Justice Sotomayor in dissent. And she basically complains about the majority's lack of guidance on the officer question, the lack of guidance in the court's prior cases about who is or is not an officer. And she points to the precedents, says that there's two particular criteria. One is continuing office established by law, which exists here, but the other is the exercise of significant authority. And she argues that one prerequisite to finding that someone exercises significant authority is that they have the ability to make final binding decisions on behalf of the government. She says someone that makes just recommendations to another government or another officer who exercises their own authority, that's not enough. And she cites to some earlier legal sources that suggest that an officer is someone who has a delegated portion of sovereign authority, allowing them to bind the rights of others. And then she goes and looks at these ALJs and says, despite their extensive powers, they on their own cannot bind parties to their decisions. All of their decisions are subject to review by the commission. And even when the commission declines to review, they must issue what's known as a finality order before the ALJ's decisions actually take effect. So the ALJs on their own cannot bind anyone. It's only through the commission that they bind anyone. So she says it just doesn't mean it. Therefore, they're not officers, and that's the end of her decision there. Now, this is interesting because as far as the SEC is concerned, this case is probably going to have very little impact. The SEC doesn't have many ALJs. They already reappointed them in what they is presumably a constitutional fashion. And most cases decided before under the previous unconstitutional appointments, most of those cases didn't raise this issue, and therefore they've probably waived it and have no right to reopen those cases. So it doesn't matter much for the SEC, but this could have a much more significant impact elsewhere. There are more than 1,000 ALJs across various agencies across the government. Some agencies have numerous ALJs, and it's an open question how many decisions are potentially out there under these ALJs in other agencies that may not have been appointed by the head of the agency that may be subject to challenge now. But there are also a significant number of other adjudicatory officials. For example, there are some officials known as administrative judges, not administrative law judges, ALJs, but just AJs. And by some counts, there's more than 10,000 of those in various agencies, and they have a lot of the same powers and could potentially fall under this decision as well. So it's an open question of how much of an impact this case may have, and it just remains to be seen in future. There will undoubtedly be future challenges to various federal officials. And again, it's still a wide open question beyond these adjudicatory officials who are very similar to ALJs. What types of other federal agents, employees are actually constitutional officers? It's still an open question. That brings me to the last case of the night. I'm sorry this has run so long, but let's just finish it out. The last case is South Dakota v. Wayfair, and this is the case about the authority of states to force out-of-state retailers to collect sales tax. And this came down with a 5-4 decision. Justice Kennedy wrote the majority, joined by Thomas, Ginsburg, Alito, and Gorsuch. So it's a little bit of a mixed group. It's 4 of the conservatives along with Ginsburg. Justice Thomas wrote a concurrence, Justice Gorsuch wrote a concurrence, and then there's a dissent by Justice Roberts, who's joined by Breyer, Sotomayor, and Kagan. So again, it's Roberts joined by 3 of the liberal justices, so another slightly unusual combination. Here's a quick background. The key case here, there's a 1992 case called Quill Corp v. North Dakota. And in that case, the court held that states can't require a retailer with no physical presence in the state to collect state sales tax. And this, in turn, was based on a 1967 case called National Bellis Hess v. Department of Revenue. And these cases are based on something known as the Dormant Commerce Clause, which is also referred to sometimes as the Negative Commerce Clause. And it's the idea that the Commerce Clause is a portion of the federal Constitution that gives the federal government the authority to regulate interstate commerce. Now, the Dormant Commerce Clause it's an idea, it's a concept that it's an implication from the Commerce Clause that states, because this authority is given to the federal government, that states cannot impede interstate commerce even if Congress hasn't acted. So it's the idea that the Commerce Clause, by implication, places some limits on what states can do that has an impact on interstate commerce. So the issue here is that South Dakota, this Quill case, the 1992 case, is very unpopular among state governments who would like to impose taxes on out-of-state retailers that are selling into their state. South Dakota passed a law to specifically challenge the Quill rule. So passed a law, and a number of other states have done the same thing to some greater or lesser degree. South Dakota passed a very restrained law to try and make it a test case. It only applies to large retailers that have more than $100,000 in sales or more than 200 individual sales inside South Dakota. So it won't burden businesses that have a very small South Dakota footprint. And it also prohibits retroactive application, so it'll only apply going forward. And South Dakota basically argues that the Quill is just outdated, it should be overruled. The argument on the other side is that there's just a large part of the argument is there's just a very strong value in adhering to the court's precedent and not going and overturning a rule that's been in place for such a long time. So Justice Kennedy wrote the majority, and he starts with a kind of a historical review of the court's Commerce Clause case law. And he notes that states and the federal government have concurrent authority to regulate commerce. But he notes there's two principles that are bounding states' authority, limiting the state's authority. Now here, he's referring to the court's dormant commerce clause or negative commerce clause doctrines, but he doesn't ever use those terms in his opinion. It's he only refers to it as the commerce clause generally. It's an interesting, stylistic choice of his. But he points to these two limits on state authority. One of them is that a state cannot discriminate against interstate commerce. And the second one, this is the more important one, is the state cannot impose undue burdens on interstate commerce. So a state's regulation of interstate commerce will be upheld unless the burden it imposes is clearly excessive in relation to the local benefits of that regulation. That's the basic Commerce Clause principles. Now he points at the Bellis-Hess case. That's the 1967 case that dealt with mail order retailers and said they had to have a physical presence in the state in order to be forced to collect sales tax. But that's the precedent that Quill later relied on. He points to a later case, a 1977 case called Complete Auto, which is the key dormant commerce clause case dealing with state taxing authority. And that case established a test for when a state can tax interstate commerce. And it's basically a four-part test. It says first, it has to apply to an activity with a substantial nexus with the taxing state. So there has to be a substantial connection to the state in order for them to apply this tax. 2, it has to be fairly apportioned. 3, it does not discriminate against interstate commerce. And 4, it's fairly related to the services the state provides. So that's kind of the main precedent for state taxes. But then Quill comes along in 1992, and the Quill case acknowledged that it was arguably inconsistent with the Bellis-Hess. The Bellis-Hess case, the earlier 1967 case, was arguably inconsistent with Complete Auto, which set this taxing rule. But it continued the rule. It upheld the Bellis-Hess rule requiring a physical presence and kind of equated that physical presence with the substantial nexus requirement in the Complete Auto case. So that brings us to that's Kennedy's kind of brief review of the major precedents in this area. And that brings him to the case for overruling Quill. And he kind of runs through a number of reasons. He says, first, physical presence is not necessary for substantial nexus. Substantial nexus is generally considered to be related to due process concerns, that there's enough of a connection with the state that there's some real authority for the state to be regulating some particular entity. And he says there's well-settled precedent that state authority can extend to out-of-state parties that don't have a physical presence. And that also physical presence is not really related to compliance burden. Just because some entity has some small physical presence in a particular state doesn't really relieve all of the burden that they have of complying with the state's tax requirements, so it's not a good fit. Then he says that the Quill rule actually creates market distortions. It puts local businesses and those national businesses that have a physical presence at a disadvantage to these out-of-state businesses without a physical presence who can who don't have to charge the sales tax. And it also creates a perverse incentive for businesses not to create a physical presence inside states where they otherwise might, because they don't want to subject themselves to the tax collection responsibility. And also, he says it imposes arbitrary formalistic distinctions. You may have economically and very similarly situated businesses, and they differ only based on the location of a particular warehouse, and that causes them to be treated differently for these tax purposes. And he also notes, he says that the internet really undermines the physical presence line. He says there's some real questions about what physical presence means when you're dealing with the internet. Is a website viewed on a customer's computer, is that a physical presence in the state? What if that website places tracking cookies, so that's files on a end user's computer that allow it to track a particular user? What about an app that's downloaded to a customer's phone? Does that create a physical presence? So he says the internet kind of undermines this, and also the physical presence rule isn't a good match to the reach of internet businesses. Many internet businesses have a very vast reach, the kind of the scope of who they touch, that is completely distinct from their actual physical presence. And finally, he says that this rule is just a huge burden on state governments. So then he addresses the issue of precedent. So stare decisis, that's just a fancy legal term for abiding by prior precedents. The concept that courts should stick with there's a value to adhering to precedents, even if they may not be ideal or correct as an original matter. But he argues here that although Congress is in a position to an interesting thing. This is an interesting thing about the Dormant Commerce Clause jurisprudence. The Commerce Clause, the idea that Congress has the power to regulate commerce, that's a constitutional rule that defines the scope of Congress's authority, and it's not within Congress's power to change. The Dormant Commerce Clause is a little bit different. It creates a constitutional default that says that where Congress hasn't acted, there are things that the states are forbidden from doing. But that's just a default. The Congress can always step in and allow states to act in those areas. So it's kind of a different situation. And in this way, some argue that for those purposes, the Dormant Commerce Clause should be considered very similar to a statutory situation, a situation of statutory law. And there's a distinction that's often drawn for purposes of precedent between constitutional rules and statutory rules, where the courts are the only ones who can overrule an incorrect constitutional decision. But in theory, an incorrect statutory decision can always be overruled by Congress at some later date. So this is often used to justify a much stronger version of precedent for statutory rulings, because the idea is Congress can always step in and fix it, so the courts don't need to go back on their prior decisions. And the argument is made often that that same principle should apply in the Dormant Commerce Clause space, because Congress is free to step in and change things. Kennedy disputes this, basically saying, while Congress can change, in this case, the physical presence rule, it can't change this constitutional default. And as long as this constitutional default is in the case law, the courts should step in and change that, because that's a rule that only the courts can deal with. And he goes on to say, these earlier cases, Bellis, Hess, and Quill, they never anticipated the explosion of e-commerce, and the fact that happened and completely changed the retailing landscape really undermines the value of those precedents. And then he points to real problems that are caused by the physical presence standard. He says that state laws, there's state laws that are kind of creatively defining physical presence to include, digital things like downloading an app, as I mentioned. There's efforts by states to impose paperwork requirements on out-of-state sellers that don't actually require them to collect taxes, but there's all these workarounds that states are trying to use to be able to effectively collect these taxes, and so these problems kind of undermine the idea that there's a lot of interest in relying on these previous precedents. And then he points to he addresses a concern about practical problems with this. There was a lot of concern about the burden that this rule might create on retailers who would suddenly have to deal with all the various different tax rules in all the different jurisdictions across the country. But Kennedy is fairly confident that software solutions will emerge that will make this a much more manageable problem. And he also points out that if there are bigger problems, Congress can always step in to try and alleviate those problems. So that's the majority. So moving on quickly, there are two concurrences, short concurrences by Thomas and Gorsuch. Now, Thomas is interesting. He was on the court at the time of Quill, and he specifically writes to say that he basically regrets his vote in Quill to stick with the Bellis-Hess rule, and says he should have joined the one justice who dissented and voted to overrule Bellis-Hess at the time. But he goes on to, and this is a position he's staked out in previous opinions before, but he basically rejects the court's entire Dormant Commerce Clause jurisprudence. He argues that if Congress hasn't acted in an area, the states are free to act, and the whole idea that there's just these zones where even if Congress has done nothing, the states are not free to go, that's a mistake that the courts invented out of whole cloth and should be done away with. Now, Justice Gorsuch has a concurrence that's on a somewhat similar vein. He agrees with the majority that the Dormant Commerce Clause jurisprudence doesn't justify the Quill rule, so he agrees that it should be overruled. But he calls for reconsideration of the entire Dormant Commerce Clause area. Now, unlike Thomas, he leaves open the possibility that that some or at least some part of the Dormant Commerce Clause jurisprudence may be in some way justifiable, possibly under different rationales than the court has previously used. He leaves that open as a possibility, but he thinks the court should really revisit the whole area. So let's move on and try and wrap this up with the dissent in this case. And again, that's Justice Roberts, Chief Justice Roberts, writing the dissent here. And his dissent is heavily reliant on stare decisis, this idea that the court should adhere to its prior precedents, and that there's a heavy burden to overturn a prior precedent. He interestingly agrees that the Bellis Hess case, the 1967 case that started this whole physical presence requirement, he agrees that that was wrongly decided. It should have been decided the other way at the time. But then he points to the growth of e-commerce with this as the backdrop, and says that just that is the world that we've lived in for all this time, and any change to the rule now could cause huge disruptions. And he says, and I mentioned this in talking about Kennedy's opinion, he believes the Dormant Commerce Clause should get the heightened type of stare decisis like statutes get, because Congress is always free to step in. And he points to the fact that this is something that Congress has actively considered over the years. Congress has been actively considering some overturning Quill in some way. And there are actually currently 3 bills pending in Congress that would in some way overturn the Quill rule. And Roberts kind of argues that this decision may have the effect of basically torpedoing that legislation, because by suddenly changing the baseline, it just upsets all of the legislative kind of negotiations and expectations, and the kind of finely crafted compromises that the Congress may have come up with to deal with the various concerns in this area now won't happen, at least in the short term, because of the court stepping in to change the rule. He also argues that, contrary to the majority, there's really no urgency for the court to act in this area. He says the majority talks a lot about the expansion of e-commerce, the vast expansion of e-commerce, but he says they ignore the fact that an increasing amount of e-commerce taxes are successfully being collected by states. There's estimates that approximately 80% of sales taxes on e-commerce are currently being collected. A lot of this is due to compliance by some of the largest vendors. And that's an interesting point about this case. There's an assumption often that it's things like Amazon that are most affected by this, but Amazon actually already collects sales tax in every jurisdiction, every taxing jurisdiction, just as a matter of its own policy. And that's true of many of the largest retailers, either because they have a physical presence everywhere, like Walmart, for example, or just in enough jurisdictions that they find it better policy just to comply everywhere, like Amazon. So Robert says there's actually increasing compliance due to these large vendors with physical presence in a lot of places. So it's really not this major urgency to act quickly on this. And then he emphasizes this heavy compliance burden, especially on small businesses, and notes that at least the claims are that the software to deal with this, especially for small vendors, is still in its infancy, and it's questionable how accurate or cost affordable it is. And he just goes back to Congress again, saying that Congress has much more flexibility to take into account all of the varied interests and to craft a careful rule in this area. So that does it for this week's cases. I'll give a little wrap up. If anyone is still watching live and have any last questions, feel free to enter them in, and kind of a last call for questions. But otherwise, that brings us to the end of this live stream episode. The next live stream will be a week from today, Thursday, June 28th at 9 p.m. Eastern Time. And you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, after issuing this morning's opinion, the court announced that it would take the bench again tomorrow, that's Friday the 22nd, at 10 a.m. to issue additional opinions. Now, the court also had its private conference earlier today. The orders list from that conference will come out Monday morning at 9:30, and more opinions are also expected Monday at 10. So we have opinions tomorrow, Friday at 10 a.m., Monday at 10 a.m. We don't know yet whether Monday will be the last day of the term or if the court will schedule additional opinion hand-down days. If it does add another day, Tuesday or Wednesday are good bets, because at this point, the justices are eager to finish so they can start their summer recess. But at least we'll have some opinions coming down Friday and Monday, and then we'll see when they actually get the last of them out. Now, as a reminder, 10 cases are still pending, and this includes several major cases, including Carpenter v. U.S., that's the case about whether the government needs a warrant to obtain cell site location data. NIFLA v. Becerra, that's the case about the California FACT Act, which is requires certain disclosures about the availability of abortion by crisis pregnancy centers. Janus v. Asks Me, which is the case about union collective bargaining fees, and Trump v. Hawaii, which is the travel ban litigation, the highly anticipated case about the ban on entry of nationals of certain countries. So there's a suggestion in the live stream, maybe break it up into 2 episodes instead of 1. I may try to do this. This was awful long. This was even longer than I anticipated. So I might try and do that. It's just going to depend on exactly when the opinions come down, and frankly, just whether I have time to read and process them in time before I have limited time in which to do that. So I don't know how feasible. I know I can get through everything by Thursday, but I'm not sure how much I'll be able to get through earlier in the week if I wanted to do 2. It's a good suggestion, and I'll think about that. But as of now, I'm planning to just do Thursday. We'll see how that goes. But that wraps it up for tonight. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com. on the Counting to 5 YouTube channel or Facebook page. You can tweet at Counting to 5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. Thank you for listening. This has been Counting to 5.